He has decided some of the area's most high-profile discipline cases for fired officers, deputies, and firefighters. But tonight, this arbitrator's own background is under scrutiny after public records show he intended to defraud creditors while filing for bankruptcy. KSAT Investigates' Dylan Collier examines the potential fallout.
After San Antonio police officer Matthew Luckhurst was fired twice for separate incidents involving feces, including the disturbing allegation that he gave a poop sandwich to a homeless man, it was arbitrator Thomas Cipolla who ultimately kept Luckhurst from ever returning to SAPD. In June 2020, Cipolla ruled that one of Luckhurst's indefinite suspensions should remain in place. Luckhurst defecated in a bike patrol toilet and then spread a brown substance on the seat, leaving the mess for a female officer to find. Cipolla called the prank revolting, disgusting, and demeaning in his award that allowed the termination to stand.
We're going in. Tear gas and all.
A little over a year later, Cipolla was chosen to oversee the case of fired Bexar County Sheriff's Lieutenant Roxanne Mathai. She attended a rally for President Donald Trump that infamously evolved into the Capitol insurrection. Although Mathai never went inside the Capitol building and was not accused of criminal wrongdoing by any law enforcement agency, Cipolla upheld her termination in late 2021, noting that she should have known she was observing illegal activity and had violated department rules by not reporting what she had seen. Mathai hit the county and Sheriff Javier Salazar with a federal civil rights lawsuit last December in an effort to be reinstated. In a response filed in the case in March, Mathai's attorney, Mark Anthony Sanchez, now contends that Cipolla should have never been chosen for her arbitration hearing.
I discovered evidence that with respect to Mr. Cipolla, there were at least 3 federal courts that admonished him for engaging in a pattern of fraudulent behavior and being less than candid with the court in his representations.
Cipolla, an Austin-based attorney, filed for personal bankruptcy in 2009 after accruing hundreds of thousands of dollars in debt. Records show years earlier, Cipolla had borrowed against this home in St. Louis when buying this condo near the shores of South Padre Island, meaning he could no longer protect the asset if he filed for bankruptcy. Although Cipolla contended the condo was exempt from his creditors under Texas law, multiple courts saw it differently. A bankruptcy court found him not credible, and as a licensed attorney in both Texas and Missouri, he must have known the implications of those states' homestead exemption laws. Cipolla appealed multiple times. And although a judge later ruled it was unfair to assume Cipolla had knowledge of bankruptcy and homestead laws, the United States Court of Appeals for the Fifth Circuit concluded there was sufficient circumstantial evidence to support the finding that Cipolla had acted with the intent to defraud.
Mr. Cipolla engaged in a pattern of profligate spending. He was up to his eyeballs in debt. And I think the courts looked at some of his statements and some of his filings and found that he was motivated by a desire to defraud creditors and avoid some of the consequences of his financial irresponsibility. So the lingering questions that I see are, was Mr. Cipolla making a decision based on an objective review of the record, or was he motivated by greed or desperation to rule for the county in order to maintain his standing as an arbitrator and receive additional appointments?
In a phone call with KSAT, Cipolla called it an honest mistake and that he did not intentionally try and shield the condo from his creditors, adding that he eventually had to sell the property to help satisfy his debts. Mathai's union attorney, Morris Munoz, told us he never would have signed off on Cipolla hearing her discipline case if he had known about the arbitrator's past financial problems.
I mean, that's a pretty serious, situation that, he caused for himself.
And Mathai's federal suit is still in the discovery stage. The judge last week denied a motion from Bexar County to dismiss it. Back to you.
Now, Dylan, let's go all the way back here, because who provides the arbitrators whenever a police officer or sheriff's deputy is fired and they want to fight that punishment?
Stephanie, those arbitrators for both San Antonio and Bexar County civil service appeals are provided by the American Arbitration Association, or AAA. AAA did not respond to multiple requests for comment on whether Sapola will be included on the city's list moving forward for future arbitration hearings.
And Dylan, what about Bexar County cases now?
Well, Sapola himself told us that he is still scheduled to be the arbitrator for upcoming Bexar County discipline cases. A Bexar County official says Sapola is no longer on the panel of agreed upon arbitrators, so they're now trying to determine if that is appropriate since he's not on the official list.
So let's talk about Sapola. What did he have to say about all this?
Well, Stephanie, he did not want to be quoted directly for this story. He was afraid about being subpoenaed in this federal lawsuit. But when asked whether his past issues impact his ability to be impartial, he said, quote, absolutely not. It is worth noting that we could find no record that he was implicated in any professional misconduct or subject to any professional discipline in connection with this 2009 bankruptcy case.
Dylan Collier, thank you so much for that.
Interesting case. Appreciate it. You know, he'll stay on top of that.